A Supreme Court decision just dropped that is being misunderstood by almost everyone who's sharing it online. And if you repeat the wrong take, you could end up making a mistake that doesn't just embarrass you, it could cost you your freedom. So before we go any further, quick question. Are you subscribed? Because what I'm about to break down could literally keep you out of a federal felony situation. Hit that button now. All right, here's the headline you've probably seen everywhere. Breaking Supreme Court 8-1 decision just changed both First and Second Amendment rights. Here's the truth. There is a real 8-1 Supreme Court decision tied to the Second Amendment, and there is also a massive Supreme Court fight tied to the First Amendment that directly affects gun owners, gun shops, and digital advocates. But they are not the same case, and mixing them up is exactly how people get confused, get scared, and make dangerous decisions. So in this video, I'm going to do 3 things for you. First, I'll explain the real 8-1 decision, what it actually held and what it did not hold. Second, I'll show you how the First Amendment is now being used as a backdoor to pressure gun owners, gun businesses, and gun advocates without passing a single new law. Third, I'll give you the January 2026 warning, the specific legal deadline you need to understand before the rules change again. Because if you don't know this, you aren't just risking a technical violation. You are risking a permanent loss of rights under a legal framework that didn't even exist 2 years ago. Let's start at the beginning. The case is called United States versus Rahimi. Here's the simple question the Supreme Court answered. Can the federal government temporarily ban someone from possessing firearms if that person is under a domestic violence restraining order and a court has already found that person is a credible threat to someone's physical safety? The Supreme Court said yes. That's the headline in plain English. If a judge has found you are a real, documented threat to someone's safety, the government can disarm you while that order is active, and it does not violate the Second Amendment. Now, I want you to notice carefully what the court did not say. They did not say the Second Amendment is gone. They did not say anyone who is accused of something automatically loses gun rights. They did not say states can disarm people simply because they feel like it. This decision is about a specific type of court order with specific legal requirements and a specific kind of finding, a credible threat. That detail is everything, because a lot of people online are treating this like the court just approved broad gun bans across the board. That is not what happened. Now let me tell you about the man at the center of this. Zaki Rahimi was, to put it plainly, not a law-abiding, responsible citizen. He was involved in 5 different shootings over the span of 2 months. He shot at a bystander who witnessed him assault his girlfriend. He shot at a police car. He fired a weapon into the air at a fast food restaurant. But he had not been convicted of those crimes yet. Instead, he was under a civil domestic violence restraining order. Under federal law, if you are under such an order, you cannot legally possess a firearm. Rahimi's lawyers argued that in the 1700s there were no laws specifically disarming people for domestic violence, and therefore under the Bruin history and tradition test, this modern law must be unconstitutional. The Fifth Circuit Court of Appeals actually agreed with him, and that is where the Supreme Court stepped in. Chief Justice John Roberts wrote the majority opinion and said something every gun owner needs to memorize. He said the Second Amendment is not a law trapped in amber. Think about that image. A bug in amber is frozen. It cannot move. It cannot adapt. Some lower courts were acting like the government had to find a 230-year-old law that was an exact copy of any modern regulation. Roberts said, stop doing that. The court clarified that Bruin does not require a historical twin. It requires a historical analog. An analog just means the law follows the same principle, the same why, and the same how. The why is the law targeting a specific proven threat of violence. The how, does it burden the right in a way that is temporary, proportional, and backed by due process? That is the new battleground. Now, if you follow gun law even a little, you've heard of Bruin. After that decision, lower courts started fighting about what history and tradition actually means. Some judges demanded a perfect copy of a law from the 1790s to justify any modern regulation. Rahimi is the Supreme Court looking at that chaos and saying, enough, stop demanding the impossible, use analogy and principle. And that matters in 2 directions at once. It makes it somewhat easier for the government to defend targeted, narrow regulations, but it also forces the government to prove their case, to show a real historical principle, not just wave their hands. No blank checks, no category labels, no vague appeals to public safety. The court even went out of its way to reject the government's attempt to use the phrase responsible citizen as a broad standard. Chief Justice Roberts basically said that responsible is too vague a term. We are not going to let the government decide who counts as responsible and use that label to strip constitutional rights. That is huge. By rejecting that framing, the court prevented the creation of something like a social credit system for gun ownership. You don't lose your rights because someone in government thinks you are irresponsible. You lose them if, and only if, there is a specific historical principle, like being a proven credible threat, that justifies it. Now let me make this real with a scenario, because this is how you actually remember it. Imagine a guy named Mike. Mike is not a felon. He is not in a gang. He owns guns legally, carries legally, and has done everything right. But he is going through a bad breakup. Things get tense. One night he sends an angry text, not a threat in his mind, just venting frustration. The next morning he gets served with a protective order request. Here is the mistake most people in Mike's situation make. They think this is family court stuff. It's emotional. It's personal. The judge will see that. But the court is not reading Mike's mind. The court is reading what is on paper, and if an order gets entered that includes findings about credible threats or danger to physical safety, Mike's gun situation changes overnight, even though he has never been convicted of anything. That is why you cannot treat a restraining order like drama or temporary inconvenience. Temporary can still mean handcuffs. Temporary can still mean thousands in legal fees. Temporary can still mean a permanent mark on your record. Take it seriously early, get real legal counsel, and never send just one more message. So here's what changed for gun owners after Rahimi. Number one, credible threat is not just a phrase anymore. It is a legal trigger. If you are ever involved in a protective order situation, you need to understand exactly what the order says. Does it contain a finding that you are a credible threat to physical safety? Does it explicitly reference threats or force? Those specific words can decide whether simple possession becomes a federal felony. Number two, notice and a chance to be heard matters enormously. The reason the law in Rahimi survived is partly because it involves court procedures. The system is supposed to give you a chance to respond before restrictions kick in. That means you must show up. Ignoring it makes everything worse. Number three, Bruin is still the test. But now courts must apply it honestly. A judge can no longer simply say there was no matching law in 1791, so the modern regulation fails. They must ask whether the law matches a historical principle in the ways that matter. That can cut both directions. It can save some regulations. It can sink others. But the standard is now principle over perfection. Now here's where the story takes a turn that most gun owners and even most legal analysts are completely missing. While the Supreme Court was clarifying the Second Amendment in Rahimi, they were simultaneously fighting a separate war over gun speech. And this is where the First Amendment becomes just as important as the Second. There is a term you need to know, jawboning. It sounds harmless. It refers to what happens when government officials use informal pressure, phone calls, emails, so-called guidance letters, to get private companies to do what the government cannot legally do directly. And this is not a theory. The Supreme Court took up two massive cases last term that prove the First Amendment is now the primary backdoor being used to put pressure on gun rights without ever passing a law. The first is NRA versus Vullo. The Supreme Court ruled 9-0 in favor of the NRA, 9-0. That is as unanimous as it gets. Here is what happened. A high-ranking regulator in New York began leaning on insurance companies and banks. She did not pass a law banning the NRA. Instead, she issued guidance letters suggesting that doing business with gun groups posed a reputational risk. Behind closed doors, she allegedly told insurers that if they dropped the NRA, certain regulatory problems of their own might quietly go away. The Supreme Court saw straight through it. Justice Sonia Sotomayor, one of the court's most liberal members, wrote the opinion. She said that a government official cannot use the power of their office to coerce a private company into punishing someone for their speech or their associations. Why does this matter to you? Because the fastest way to destroy a gun organization is not to outlaw it. It is to make it impossible to maintain a bank account, impossible to buy insurance for your range, impossible to process credit cards, impossible to operate. That 9-0 decision was a massive shield for every gun business and advocacy group in America. But it has a paired case that is not nearly as clean a victory. Murthy versus Missouri is where things get complicated. In this case, several states and individuals sued the White House and the FBI, arguing that government agencies were pressuring platforms like Facebook and YouTube to shadow ban or delete content, including posts about gun rights and self-defense. Unlike the NRA case, the Supreme Court ruled 6-3 against the plaintiffs here. But here's the critical detail. The court did not say the government's actions were legal. They said the plaintiffs lacked standing. In plain English, the court said they believed the pressure was probably happening, but the plaintiffs could not show precisely which government email caused which specific post to be removed. This creates what you have to understand as a gray zone. Right now, government agencies still feel they have an informal green light to nudge social media algorithms to bury gun content, to label safety training as harmful, or to flag gun advocacy as a public risk, and they can do it without leaving a clean paper trail. That is the threat that lives in the background of everything you post. Most gun owners say they only care about their carry permit and their Second Amendment rights. That is the mistake. The Rahimi decision and the Vullo and Murthy decisions are two sides of the same coin. The Second Amendment protects your right to own the tool. The First Amendment protects your right to organize, advocate, and fight to keep it. If the government can pressure banks to defund gun groups and platforms to bury gun content, they can effectively dismantle the Second Amendment without touching a single firearm. Think about it this way. Your right to speak is the engine that lets you defend your right to carry. If you cannot speak, you cannot rally support. If you cannot organize, you cannot fund lawsuits. If you cannot advocate, you cannot push back. Both amendments are one fight. And that brings us to the January 2026 warning, and why the timing right now is so critical. We are heading into a major legal bottleneck. Two landmark cases are moving through the courts that will serve as the real-world stress tests for the Rahimi framework. The first involves what critics are calling sensitive place expansions. States like Hawaii and California have passed laws banning firearms on all private property open to the public unless the owner explicitly posts a sign welcoming them. The government is using the Rahimi historical analog test to argue that because the Founding Fathers restricted guns in sensitive places like legislatures, modern states can now ban guns essentially everywhere people gather. If you hold a carry permit and assume civil space means safe space, you need to stop making that assumption. In 2026, a sign is not just a suggestion, it is a legal tripwire. The second case involves what is being called the habitual user question. The Supreme Court is hearing arguments on whether the government can permanently disarm someone who is an unlawful user of a controlled substance, including marijuana, even if that person has never been convicted of a violent crime and is not impaired at the time. Using the Rahimi logic, the government is arguing that habitual users are inherently unstable, similar to the credible threats in domestic violence cases. If the court sides with the government, they will not need a restraining order to disarm you. They will only need evidence of habitual use. And in a world where your social media posts can be flagged and shared with law enforcement, the gray zone left open by Murthy, your digital footprint becomes your paper trail. This is the pincer move. They are narrowing the legal right to carry through the courts while simultaneously maintaining the ability to silence the digital right to organize and complain about it. And the two pressures are designed to meet in the middle. So what do you actually do? Here is your practical checklist before January 2026. First, audit your legal paperwork. Pull out any court orders, protective orders, or legal documents you have ever been part of. Read them, not skim, actually read them. Look for the words credible threat, physical safety, violence, or firearm restriction. If you find them, do not panic, but do act immediately. Find a lawyer who understands both family law and federal firearm law in your state. Second, audit your digital footprint. Go through your social media, your texts, your emails. Search for words like threat, hurt, gun, fight, and even casual references to substances. Now ask yourself honestly, if a judge saw this out of context, what would they conclude? If the answer is anything other than nothing, clean it up. Not because you are guilty of anything, because context is fragile, and in a legal proceeding, your words can be used to build a narrative you never intended. Third, diversify your financial infrastructure. If you run any gun-related business or organization, do not depend on a single bank or payment processor. Research alternatives now before you need them. If a financial institution ever drops you without a clear explanation, demand the specific policy or guidance in writing. That paper trail is your only real defense against the backdoor pressure the Vullo case exposed. Fourth, build your legal network before you need it. Find a lawyer who understands gun rights, First Amendment issues, and how they intersect. Join organizations with legal defense funds. When you need help, you will not have time to search. Preparation is not anxiety. It is freedom. Now, before we get to the final warning, I want to bust the 3 myths I keep seeing in the comments on every video about this topic. Myth number 1. If I'm not under a restraining order, none of this applies to me. That is false. The First Amendment pressure campaign affects every single person who talks about guns, sells gear, teaches classes, or creates content. You do not have to be in a courtroom for this to reach you. Myth number 2. The Supreme Court just said gun rights are shrinking. Also false. Rahimi was a narrow decision. It addressed one specific law in one specific set of circumstances. It did not overturn Bruin. It did not gut the Second Amendment. It told courts to apply the existing test correctly, and that actually helps gun rights plaintiffs in future cases by forcing judges to be honest about the history they use. Myth number 3, I can post whatever I want online, and it has no legal consequences. Completely false. Your posts can be entered as evidence. They can be used to support a restraining order application. They can be used to establish a pattern that a prosecutor describes as a credible threat. In a post-Rahimi world, law enforcement and opposing attorneys are actively looking for what they call analogs of danger: agitated behavior, escalating language, confrontational patterns. Your social media is their research library. So think before you post, not because you are doing anything wrong, because precision is protection. Now let me leave you with this. Most people do not lose their rights in a dramatic moment. They lose them in boring ones. A court date they did not take seriously, a form they skimmed instead of read, a text they sent without thinking, a restraining order they assumed was just paperwork. The law does not care that you are normally a careful, responsible person. The law cares about what is written, what is filed, what is ordered, and what you did next. The Supreme Court has given us real tools to fight with. The Bruin framework is intact, the Vullo victory was unanimous, and the Rahimi decision is narrower than the headlines claim. But the government now has a roadmap for working around those tools. Your job is to know that roadmap better than they do. Stay precise, stay documented, stay boring. And whatever you do, do not learn any of this the hard way in a courtroom. Final disclaimer, this is general educational information, not legal advice. Laws change, facts matter, and every state is different. If you have a real legal situation, talk to a qualified attorney before you take any action. Your rights are worth protecting, and protection starts with knowing the rules of the game.